Oh yeah,
Do you?
that works.
Cool. This should work. Maybe.
Cool.
Maybe not. It's all right.
All right, cool. Ready to get started?
Let's see if I need the volume up.
All right. Well, good morning, everybody. Thanks. It doesn't say, so it's not working on the TV, but
It's okay.
All right.
It's all right. Oh,
Good.
we'll be fine.
all right, cool. Good morning, everybody. Thanks, everybody, for hopping on today, and thanks for having me. We're going to talk mostly about the South Carolina contract that just came out with some fun new revisions. There's a little bit about what we're going to talk about today. I'll just introduce myself and our firm a little bit real quick first, but I am with McMichael and Gray. I'm the managing attorney in our Charlotte office, currently the only attorney in our Charlotte office um, until our job posting gets fulfilled. But I am in Charlotte. We have an office locally also in Rock Hill with a full staff down there. We have an office in Greenville, South Carolina, and most of our presence is in Georgia. Actually, we have about 15 offices in the state of Georgia around Atlanta, and then we're also in Tennessee, Alabama, Florida, North, South, Georgia, and those 6 states total. So we're a pretty big firm. We got about 300 employees total now, about 40 or 50 attorneys, I think. But locally, so we have a big firm supporting us, but locally we're small offices and small teams. So we like to give that sort of personal touch, personal effect of a smaller firm, but we have the resources behind us to help us with some nice software and attract talent and things like that. Our office has been open almost 5 years now in Charlotte, and we work with everybody from builders to individual home buyers, investors, and everybody in between. A few things I think we do pretty well. We are able to get title done pretty quickly. We do a lot of our title searching in-house, so we're able to get that back usually in less than a week or so. Someone just asked me about flipping a contract to us, and I told them we get title by the end of this week. So usually we're able to push things forward as we need to and expedite things and stay flexible. We also always match you with a dedicated paralegal. So whenever you have 2 closings with us, 5 closings with us going at the same time, it's always going to be with the same person. So you don't have to track people down or figure out who to talk to or who's the right person or talk to somebody who knows nothing about you. We also are very, very careful about what we do with money. We're very particular about wiring money in and out. We can't prevent everything, but wire fraud and check fraud and everything is a really big deal and a really big problem. So we work really hard to combat those efforts because people are out there coming to get us every day. A couple of different things I'll flip through quickly. We use some nice software platforms that make intake a lot smoother for clients. So our information forms are all electronic. It's all typing into a website, not a PDF or a Word doc or anything. It comes right back through to us on the back end and imports into our system automatically. So that's pretty cool. We're doing earnest money by this app now. It's all electronic transfer, and we've been sort of beta testing it for the firm for the last few months and learned some things about it. But it's got some really nice capabilities that help out a lot of people. Saves agents the liability of carrying checks around town and buyers the hassle of trying to drive it over themselves. So we like that a lot. I have to get this out of the way. We're going to talk about some things today. Nothing about what we talk about is going to create any attorney-client privilege or anything like that between anybody on here. This is all informational only, educational, but if you have specific scenarios and buyers later on, obviously we can talk more specifically about their situation. So I'm going to start with a pop quiz for everybody. What percentage of business, and you could put this in the chat if you're on Zoom, what percentage of your business, say for this year, is going to be in South Carolina? Say 100%, 50%, 75, 25. Let's see what people are going to say.
Mm-hmm. I would put it in the chat, but you have mine.
Yeah, you 50, 20, So a little bit of a range.
So far, all mine that have closed have been South
As much
Carolina.
as possible. Yeah. I always like to know kind of like, I typically operate from like North Carolina is where I started and got licensed first, and South Carolina is newer. So to the extent agents are practicing up here and dabbling down there, it kind of makes a difference how we talk about the South Carolina contract. But all right, everyone passed the question. When you're writing contracts in South Carolina, this is for everybody, do you put in an address, a notice address for the seller, or do you not? In South Carolina, like if you're a listing agent, do you have an address for the seller
No.
On the listing agreement,
on the contract?
on the offer to purchase and contract?
Mm-hmm.
Yes.
You do
Is
put
it
their
in
address.
there?
Yeah.
There's a place for it, but
Yes, but it's my address. It's not their personal address.
that's fine. Yeah. So like there's a notice address.
Oh, no, I leave that blank.
And a lot of people do, but that's going to be relevant for what we talk about.
So glad, yeah.
That's why we have you, Charlie.
Might be time to
Yeah.
start.
Cool.
We'll see why.
Okay. I
Um,
better write a note in that section.
and these are more rhetorical questions, but has anybody ever dealt with a client that doesn't have a checkbook
Yes.
All the
Mhm,
time.
yeah.
I
All the
don't have one.
time.
or a seller or buyer that's out of town?
All the time.
What was my other one? What's the main ones?
It's yours. Yeah.
So we're going to come back to that notice address, but that's going to be relevant to what we talk about. Shit, what we got? Yes, yes, yes. Everyone else is doing it for you, it seems like.
We
Okay.
just heard her answer.
Yeah, they heard my answer and they went off it. That's what I'm just
They're just
saying.
trying to get the question right.
Or
They're
they
trying to pass
might
the
actually
quiz.
really do the right thing. Don't
Yeah.
go off of what I do. Do as I say, not as I do.
Yes.
Right?
Yes.
Well, we're going to need to address that notice address, and we'll see why. So we'll get into the contract. This is for the South Carolina contract for what has changed in 2022. This part's easy. Not much has changed. There's paragraph 8 that talks about repair options. And starting this year, they've deleted the options. So they don't have the repair procedure paragraph is gone. And then the as is paragraph is gone. So what's left in the middle is only one paragraph about due diligence. And it's the due diligence period. And that's how every contract is going to be. Now, there's no confusing option to select or anything like that. It's just all due diligence. You got to pick the date, the end date, just like you would do in North Carolina, but you're not picking repair procedure or as is or anything like that. I think that's a good thing. I think that always confused people. I think people always were questioning whether repair procedure is better. What's the seller going to prefer to see on their offer? What's going to get accepted? And I think I never got a consistent answer from anybody about what was ideal there. So I think that's good. It takes a variable out of it. So now all we've got is a due diligence period. This makes South Carolina a little bit more like North Carolina. We've got a standard built-in due diligence period and a fee. It's a little bit different. South Carolina, the SCR still insists on hard dates being entered into contracts. So if you're writing up an offer tomorrow, your due diligence period needs to end on July 20th or July 25th. It's not ever going to be 7 days after the contract is signed, which can be challenging in my opinion, because you might submit an offer today and then it gets accepted in an hour or it gets accepted in 4 days and you don't know. So you're committing yourself to a due diligence period, not knowing when the beginning is going to be. But that's all about being attentive and being organized and being in communication more than anything with listing agent and everybody involved. All right, so there's a termination fee now that's always been there, but this is your only option in South Carolina now. A little bit like the North Carolina due diligence fee, it's the buyer paying for the right essentially to do their due diligence on the property and go under contract. I think in a seller's market that turns into the buyers are going to have to compete over that number. You're probably going to start seeing high termination fees because that's what sellers are going to want to see accepted. Now, I've made this presentation originally 2 or 3 weeks ago, and this already feels kind of out of date because things are shifting a little bit. But on the other end of the spectrum, and if we're in an extreme buyer's market, then I think it's challenging for the seller because they might, in some cases, be giving almost free looks at the property if the termination fee is low. But question?
So yeah, that fee. So we're putting the earnest money in here, and that fee
Mhm.
only. So how does that get dispersed? So we know it's part of the earnest money. So earnest money is 5,000. Due diligence fee is 2,500. We decide to walk away as a buyer.
Mhm.
Do you, the lawyer, disperse those checks to either party? Like you take the 5,000, give the 2,500 back to the buyer, and then the 2,500 due diligence fee, termination fee to the seller? How does that work?
So this is where North Carolina and South Carolina diverge mostly, is that termination fee is not ever going to be paid unless you're going to actually terminate.
Yeah, say
And
I am
so-
terminating.
right.
How does that work?
So buyer decides to terminate, well, the check is still in their hands. So the termination is going to go directly to the seller. Like,
So you're gonna pay the whole earnest money back to the buyer then?
so the earnest money is going to be completely separate from the termination fee. So earnest money, say $5,000 sitting in my account at the law firm.
Yep.
That's going to be a completely different question and answer than this termination fee.
But we don't have to pay the termination fee unless the buyer walks away, correct? So
right.
that's gonna be so the way I see it, that when we decide to terminate, we have to have our buyer
Mhm.
write a check to the seller for that termination fee.
Right.
Get the paperwork signed, and you're gonna cut the $5,000 earnest money check back to the
Right.
buyer. Okay.
But we'll skip
So your termination fee can actually be higher than your earnest money deposit.
higher,
Yeah.
lower. It's completely
It doesn't come
separate.
out of the other.
Okay, cool.
Gotcha.
Yeah.
Sorry, did I skip a step?
No, no,
Okay.
it's okay. We're going to cover this in a second, but since we're going there right now,
Sorry.
that's good. It's one thing I hate about the South Carolina contract is that it's completely devoid of any earnest money direction. So in North Carolina, we're used to, I terminated during the due diligence period, I get the earnest money back.
Mhm.
And the termination agreement or the termination notice has the box you check, and it says the seller's releasing earnest money. It's not on here. So just by terminating during the due diligence period, you're not automatically entitled to earnest money back as the buyer.
So what gives them the entitlement to the earnest money back then?
It has to be by agreement. Everything
That's
has to be
it.
by agreement.
Oh boy.
A separate
guys.
agreement.
You all
Yeah.
hear this? This is getting
Yeah.
scary.
That's what I don't like.
Do you have an amendment that we can use that specifies that if we terminate during due diligence, that the earnest money is returned to the buyer?
That's a good one.
I don't have one yet, but I can get one. Yeah,
If
that'd
you
be
could
fine.
draft one for that, that would be helpful.
Yeah.
Yes,
But
please.
good luck getting your offer accepted with that, especially in South Carolina, because they're gonna fight this to begin with.
And
South
the-
Carolina does not like this change.
So I feel like, so I talked with another listing agent over the weekend, and we both were unaware of how that worked. We were unsure on how it worked, and her and I talked through it, and we weren't sure how that worked. That's why I
The
asked
earnest
you
money?
that question. Yeah.
Well, and this is a quick backstory, but a few years ago, somebody in South Carolina had a grievance filed against him. It was a broker that was holding earnest money, and there was a claim made against him for something completely unrelated. In the course of that proceeding, they had an older version of a contract where it was more like North Carolina. Something was terminated, contract was terminated, and they dispersed earnest money to the buyer. And there was no separate earnest money release signed or anything. They just said the contract says earnest money goes to the buyer, we send it to the buyer. So as part of this ruling in this grievance, the South Carolina Realtor Association, is that? No, not the,
LLR.
yeah, the licensing board said, despite what anything in the contract says about earnest money, you must have a separately signed release document. So what the SCR did with their contract as of 2020 is they just hit select all and delete. Earnest money you see anywhere is gone from the contract. So there's no scenario in the South Carolina contract where earnest money is automatically determined to go anywhere. North Carolina, again, it
Yeah.
says terminate before the end of the due diligence period, get your EMD back. And everyone understands, we signed the termination, we signed the EMD release, and this is where it has to go. Here, it doesn't say that at all. It doesn't say anything.
Mm.
So yeah, hopefully if you terminate during the due diligence, the seller is going to say, here's your earnest money. I agree, take it back. But they don't have to necessarily. And I think in South Carolina, they sort of overestimate the ability or willingness of the parties to agree on everything, and just assume that in most cases all the parties will just agree naturally, but in those few where they don't, they can just go to court and go to arbitration, and we've
I
got
can
this
see
free.
where a couple sellers and buyers would fight over this earnest
Well,
money.
and you get emotional about it, and
Yep.
people get fired up about something that's happened already, and even if they don't have any case against it, they can still be stubborn and not sign it,
Mhm.
and that locks our hands as the escrow agent. We can't do anything unless they've signed, and it doesn't matter when and where and what happened. We have to have that signature. So
Mhm.
I think it presents challenges not having anything in that contract about earnest money. But back
I have
to
a
that.
question.
Yeah, go ahead.
I have a concern over the termination fee. You're saying that once they want to terminate, at that point, the buyer has to turn over the termination fee check to the seller, correct?
Before 6 p.m. Mhm.
What's the repercussion? I mean, at that point, you could be two or 3 weeks into a contract, and now the buyer wants to back out, and you have to go, hey, buyer, you've got to cough up a check now. What's the repercussion there? I have a feeling there's going to be buyers that are going to be like, I'm not going to give them money now.
Right.
Where is that? How do we go about protecting our sellers in a situation like that as well?
Well, I mean, the main takeaway for me from this whole contract is, to me, it makes your life more complicated. It creates extra steps in the process that's already busy enough for you. There are solutions. That's the good thing. It just takes a little more time and effort. But from the listing side, I mean, education, I think, is a big part of it, is
Right.
preparing your buyers and sellers for what's in this contract, what you're signing ahead of time. It's not just this big number on page one. There's some rules you got to play by too.
Right.
On the flip side, it puts all the burden on the buyer. I mean, if the buyer doesn't deliver the check, then it's on them. And at 601 on that due diligence day, it's an as-is contract, and they don't have the right to back out anymore. So, which poses some other problems we're going to talk about. But that's really from the buyer side, to me, that's the bigger issue is, I don't want to pay this check. Well, do you want to get out of this contract or not? Or do you want to buy the house?
Right.
That's the time crunch, and that's the liability that's on the line. And
Okay.
if you haven't educated them enough on that, then that's, risk there too. So to me, that's the biggest worry, is from the buyer side.
Hey, Karen, I see that you're saying you're confused. Has this cleared any questions up, or do you want to speak up and ask questions about this?
Well, I'm curious, are we talking North Carolina? Because we keep
No,
getting
this-
back
this
to
is
North
all-
Carolina to South Carolina.
No, this is all South Carolina. We're talking about South Carolina.
I've made some comparisons
Yeah.
to North Carolina, only from the perspective of how it's different, because I think they're easy to get confused sometimes. But focusing mostly on the changes that were made to the South Carolina contract for this year. I think she's muted.
Does that help or no, Karen?
Are you still? Sorry, I think you're muted if you're saying something else.
I'm trying to learn about the changes for South Carolina so that I'm clear with that.
Mhm.
Okay.
So I'm
That's
paying very close attention.
Okay,
And it's
good.
confusing when we refer to the North Carolina contract or the scenario. So I just need to be really clear, because I like to be accurate. I don't want to be back and forth. So I'm trying to catch up with the conversation and everything else that's going on. So are we talking South Carolina contract now?
We
Yes. Okay. Thank you.
Yep. So that's the big thing is about this termination fee. It's only going to be delivered if you're terminating at the time you're terminating, but it's mandatory that it's delivered on time by 6 o'clock on the last day of the due diligence period in the contract. If it's not delivered by 6 p.m. sharp, then this contract becomes as is for the buyer, and they can't unilaterally terminate anymore. So timing is going to be a really big issue with that. You got to figure out how that money is going to get delivered. Is it a check? Is it a wire? Where does it go? When's it going to get there? Who's taking it? All those are things you have to be ready to do at the very last second.
So can I get one quick clarification? So so the fee, the termination fee, it's still going to be, if they're moving forward with the contract, if they're not going to terminate at all, they still have to turn over a termination fee at the end of that time frame. No?
Nope.
Only if they're terminating, correct?
If they're terminating. Yep. Stays in the
Okay.
back. Yep.
Okay. So unlike due diligence, it doesn't stick around for the contract. It's not a credit for the buyer or anything like
Right.
that.
And so I actually had a scenario, I guess last year at this point, crazy seller's market. Seller, ironically, is a listing agent, and the buyer is also an agent, and they decided to get creative and say, hey, buyer, I need you to pay me the termination fee up front. I got all these offers. If you want to win this offer, I want your termination fee up front. And they paid it, and there's no dispute about that. We get to closing, everybody's at the closing table, and we've got a line item in there that says termination fee, just like you have earnest money or anything else credited to the buyer. And the seller goes, that's not a credit to the buyer. I'm like, well, yeah, they already paid it. They already paid it to you as part of the contract. Like, well, no, that was separate from the purchase price. That doesn't count. That was separate. And the buyer on the other side is like, no, it's not. That was included. And we had a little miniature high school debate for a few minutes, and they were both right and they're both wrong. But the contract specifically says the termination fee is only to be delivered if the buyer is actually terminating and breaking out of the contract, because if they're staying in the contract, that termination fee doesn't fit in anywhere in the purchase price or the money paid. It's only paid if you're actually terminating, and it has to be paid on time. Does that help?
Yes.
Cool. All right. So the changes to the contract itself are pretty simple. They deleted those two paragraphs, the repair procedure and the as-is options under paragraph 8. There are a couple other forms, though, that go with the contract that are going to become a little bit more important to be familiar with. And the first one I'll talk about is the repair addendum form that has been changed around a little bit for this year, going along with these changes. So last year, when we're talking about repairs in South Carolina, there's this debate about seller paid repairs and repair procedure and operable components and things like that. All that's gone. The buyer now can make any repair request that they want. The smallest thing, the biggest thing, as many things as they want, they can make any request. You can only do it once. You have one repair shot. You fill out the repair addendum. You can ask for as many or as few things as you want, and then submit it to the seller. And it takes out any guesswork about, from the repair procedure paragraph of last year, it was what does operable mean? The HVAC, is that operable or not? Well, it works, it blows, but it's not as cold as I'd like. Is that operable? Well, who's to say? Certainly not a real estate agent, not even a closing attorney. That's not something any of us should be arguing over. So we don't have to do that anymore. The buyer basically can pull anything from their inspection report and say, this needs to be repaired. And then the seller has an opportunity to respond to that request. And they can accept everything. They can cross things out. They can accept a few things. They can counter, or they cannot respond at all. The seller doesn't have to respond, but this gives the buyer the ability to ask for anything they want. This is really, really important, though. The repair addendum, the buyer submits a request. If the seller signs it, it becomes official. It becomes part of the contract. There's repairs they've agreed to. As soon as the seller signs that, if they do, the due diligence period ends immediately. And I think this is a really, really bad oversight, to be honest. Due diligence period is over as soon as that happens. So if you take a buyer in day after the contract is signed, get an inspection, there's something to repair, You submit the request that day, the seller signs it that day, you're a day into the contract and due diligence is over. You haven't done title work, you haven't done an appraisal, you haven't done survey, but the buyer no longer has this due diligence period where they can pay a termination fee and terminate. Again, I think that's a really big problem. I think that's going to cause some issues. So it brings up a timing issue of when do you make this repair request? Because you can only do it once. You can only make one request to the seller. Everything you want to ask for has to be in this one form. Do you wait until the very last day of due diligence and then they haven't had a chance to respond and they're probably unhappy about that? Do you do it the first day and then you're potentially cutting yourself off for more due diligence? Or do you have to figure out a sweet spot in the middle where you've built in enough time for the seller to reasonably respond and enough time after that for the buyer to make a decision to terminate, move forward, anything in between? So that repair request has a date on it. You can put an expiration date. And so I think my recommendation, generally speaking, would be put in an expiration date a couple days before the end of due diligence. And then you know what you're working with. Buyer's got a couple days to make a decision. Like, seller hasn't agreed to anything yet. They probably aren't going to. I got to take this house or leave it. What do I want to do? Every closing is different. Every house is different. Every buyer is different. But I think generally speaking, you got to build in some time like that where you can decide, here's what we're playing with. Here's the facts we have at our disposal right now. It's now or never. Do we buy or not? So I think that timing is, again, if you're on top of your stuff, you're informing your buyers, you're staying ahead of the process, you can get through this, but there's a lot less margin for error, in my opinion, than other states where you've got to be on the timing. You've got to know when these periods, these deadlines are coming up and keep the buyers on the phone and ready for action. So that's the repair addendum. We're going to talk more about that as we keep going, but the second.
So can I just ask a clarifying question? So in the South Carolina contract, there is the appraised value contingency. So if the appraisal comes in low, even though it's past due diligence, you still have this appraised value contingency, right? And then if the title work comes back and it isn't clear, then the seller's in breach.
Right. And so the seller still has to deliver clear title.
Right.
Now, the question of what marketable title is would be a sort of a more microscopic question. Like, what if, for example, there's an easement in the backyard? It doesn't necessarily mean the seller has breached their contract, but if you want to put that fence where you had envisioned that fence, all of a sudden this property is not exactly what you had pictured, but the seller hasn't done anything wrong. So there's still some gray area in there where it's not a breach, but it's not ideal. So having that ability to terminate in due diligence is still a valuable thing for the buyer, even if the seller is not breaching the contract. So the notice of termination, this form, it goes along with the due diligence period. So if the buyer is actually going to terminate within the due diligence period, then you're going to have this form ready to go. It's got to be delivered, signed by the buyer, delivered to the seller with some kind of proof, ideally, that it's been received. And that can even be done by email to the broker, but that's got to be done before the end of the due diligence period, 6 o'clock on the last day that you've identified in the contract. And then the second part of validly terminating is the seller has to actually receive the termination fee at the seller's notice address. So it's got to be by 6 o'clock. It's got to be received. If there's any dispute about that, ideally you'd have a way to prove that it's been received, some kind of acknowledgement, signed or otherwise. But again, the timing becomes very, very, very important. You get down to the last day of the due diligence period, you decide to terminate, the buyer wants to terminate, but you haven't talked to them at all about how the money is going to get paid. What if they, again, go back to our pop quiz, what if the buyer doesn't have a checkbook? What if the seller is out of state and can't take a check by hand? Can you wire it? Can you send it by Zelle or PayPal or something? Well, they all need to agree on that. and you've got to be ahead of that before 6 o'clock rolls around, and then the buyer's locked into their contract. So all of this becomes an issue when you're down in crunch time, and again, stresses the importance of you have to be prepared, and you have to educate your buyers on what to expect and be ready for, and deadlines coming up. So I think the way they've got this in South Carolina makes that timing much more important. Again, if you're not paying the due diligence fee or the termination fee up front, the timing becomes much more relevant than if it was already paid when you sign the contract.
Charlie,
Yeah.
Tommy Watson here. Hey, 2 questions. So as far as delivering, so what if the listing agent says, hey, I'll get that to the seller, and we hand that over to them and they hold it a couple of days? Are we still clear?
The termination fee,
Yes.
that should work as long as it actually gets to the seller. The way I read the contract is that delivery in most cases to a broker is sufficient for the buyer's obligation.
Yes.
I think that raises concerns for the listing broker about holding checks and what has to be done with that. But I think for your question, I think that suffices for the buyer's demands. I would still try to link up the timing as closely as possible with the end of the due diligence, and make it clear that we are in fact handing this to you right now because we are terminating, and not just in case, hold on to this for me, but I'm doing this on purpose because we intend to terminate, and here's the check. I think that's the safest course of action.
And this really seems to be something that I wouldn't want to put in the mail, that I would want to make sure that it was either wired into their account or
Right.
hand delivered.
You'd have to have a whole lot of days built in. What if there's bad weather, FedEx, or what if it blows out of your hand in the mailbox, or whatever? Like, there's zero tolerance. It's not, I dropped it in the mail by 6 o'clock. It's the seller received it by 6 o'clock. So the buyer doesn't get any forgiveness for anything like that.
Yep. And that's why I want to highlight this. I want the agents to hear that, hey, these are some pain points you're going to have to navigate. And if you don't mind, let me go back and touch on the repair request.
Mhm.
In this case, the way the contract reads, we got to be very careful about wordsmithing when it comes to the repair request, because if we put a general or blanket statement, fix HVAC unit, and they get somebody out there and they take a look at it and they come back and say, oh, it's fixed or it's good, that's not going to be sufficient in this case anymore. Whatever the specific problem is needs to be on that repair request, because when they sign it and move forward, if they say it's good and they've got a contractor report that says it's working properly, but yet there's still something at issue, then now we're going to be tied up. Again, a we versus them, but we're supposed to be moving forward in the contract because the repair request was signed off.
Right.
So just be careful with that.
Yeah, I think more specific the better, but like you said, you shouldn't be the ones typing in things or creating things. Ideally it's based off the inspection report. It says paragraph 4 of inspection report says so and so, we want that fixed, and there's no guesswork there.
Right. Some of those reports are general though.
Right.
So what I'm saying is we got to be specific on what the actual issue is they want repaired.
Right. Makes sense. All right. So the release agreement for the EMD, I want to highlight this. This is separate from the buyer's termination. So the buyer decides to terminate, they need to send in the notice of termination form. That's to terminate the contract, but again, doesn't say anything about EMD release. You got to have that done separately. I'd recommend probably you send that to the seller at the same time you're going to try to terminate the contract, and say, hey, we need EMD released. Also sign this while you're at it. And again, hopefully that seller is going to cooperate and everyone agrees on where the money should go. But by law, by South Carolina's regulations, it has to be signed. Something new has to be signed by both of them. So that's just something to keep in mind timing wise. You probably send that in with your termination if you're going to terminate. So this is sort of a summary of what I see are the main pros and cons for all the parties involved. For the buyer, for these changes, you don't have to make that selection anymore, the repairs option. There's no repair procedure, there's no as is contract, it's just due diligence. So I think that's good. It's one less thing to confuse everybody and argue about. The buyer can request any repairs at all. It's not like the repair procedure where they're only talking about certain components, and it's not vague at all. It just they can decide what they want. You're not worrying about operable condition or these sort of terms of art anymore that were in the contract. The buyer can rely on contractors, hopefully inspection reports, but again, hopefully they can be specific without relying on you to type things in there. The contract is still valid for the buyer, even if they request something and the seller ignores it. In the past, it was kind of like this contract can just fall apart if nobody agrees on the repairs. And then of course the buyer can terminate for pretty much any reason during the due diligence period. If they've paid their termination fee and terminate on time. So I think that's a good thing overall, even though they gotta, maybe have to cut a check for that. But some negatives I potentially would forecast: in a seller's market, there's gonna be competition over that termination fee. It's not intended as a huge amount or a windfall for the seller, but in the past it's turned into that. So I think that's a concern. But the seller doesn't have to respond at all to the repair request. Again, that puts a little bit of extra work on you as the agent. You've got to have the timing right. So even if the seller completely ignores it, you still have time to decide your next course of action. Seller doesn't have to respond. They don't have to agree to any repairs. They don't have to do anything. And then, one of the biggest cons, this is not new, but it's just something to remember, is that termination fee and the delivery logistics. You've got to be ahead of schedule. You've got to know how that money is going to get there at the last second if you need it to. For the seller, there are much more clean dates. So you have a deadline to respond to that repair request. You don't have to do it, but at what point the buyer has the ability to terminate. They have the due diligence period, the end date. What's coming up. As long as you stick with it, it's out there. The burden is on the buyer to deliver that termination fee. It's like we've been talking about. It's challenging from the buyer's perspective, but it's good for the seller. They don't have to worry about anything. It's on the buyer. If they want to terminate, they've got to get there in time. It's a good thing you can get a termination fee back if the buyer wants to terminate. In a seller's market, like we said, that fee could be pretty high. So that's good for the seller. They're not wasting time. If the contract falls through, they get a little bit of something for it. But the negatives are, again, the buyer can walk away. They've got to pay a fee, but they can just get to the end of their due diligence period and walk away. So it's important as a listing agent that you're not jumping into a contract with this long due diligence period and a low termination fee, and then the buyer can just walk away at the very end of it. If there's a buyer's market, it seems like we're moving slightly back that direction. The termination fees are going to be low for the sellers. It's going to be no termination fee or very low amounts. So it is going to be more costly to go under contract and then possibly have it terminate by the buyer. And the last one for this, there's no more as is option in the contract. I think that was probably a good thing for sellers, is having that buyers compete over that and say, we're not even going to look at anything. We'll go in as is, and this is our contract. Now, we could still contract around that. You can put in a due diligence period that's very short. So you might sign a contract and say the due diligence period is going to end in 2 days. And then after that, it becomes as is, and you're still basically in an as is contract. But all of that kind of comes back to where the market is and who's got the leverage. If it's a seller's market, then you're going to see shorter periods for that and more competition over those dates. And for the realtors, that's what we're here for, right? What does this mean for you guys? You don't have to make that confusing selection anymore. We're not deciding about repair procedure. It's just due diligence. We're just deciding on what's the end of the due diligence period, what's the termination fee, and of course, what's the earnest money amount. Like Tommy was saying, like there's less room for you to need to decide what goes in on that repair request. Hopefully the buyers can rely on their own contractors and things. You always want to reduce your own exposure to practicing law, typing in forms and contracts, or acting as a contractor, trying to make conclusions about something that's operable or something that needs to be fixed. So hopefully these changes will actually improve that. Hopefully it gives the buyers more freedom to recommend for themselves what needs to be in there. The cons, again, I've said it several times now, this termination fee delivery is a really big deal. It's how do you get that termination fee delivered? Are you going to pick up a check yourself? There's risk in that. Are you going to rely on the buyer to deliver it? There's risk in that. No. Answer no.
I will go pick it up and deliver it.
Right. And there's still risk there, but how does that happen? Where does it go? When does it go? How is it going to get there before 6 p.m.? Again, contrasting from North Carolina, where I say is a little more streamlined. Everyone knows how to terminate. You send the termination by email and it's terminated. The due diligence fee is already paid at the beginning. That's more straightforward, where the termination fee delivery in South Carolina requires just more planning. Again, I propose some scenarios here where you need to be extra prepared. The buyer does not have a checkbook. The buyer or seller is out of town or hard to reach or at work. The buyer works until 6 o'clock every day and they don't have time to cut a check. They weren't ready for this. We just had one recently that terminated where the seller lived 3 hours away and they didn't have an address in there for delivery. So wait, how do we actually deliver this to the seller? Or where do we take it to the broker? And we got done, but again, that takes more time. It's more conversations to be had and figure out where everyone agrees that it can go. Good news on that, I've already drafted a form for that. I drafted one that says, it's an amendment to the contract that says buyers and sellers agree that termination can be fulfilled by delivering to this address. So I'll share that around. Then everybody can be clear about this is where the check needs to be by this time, because the contract doesn't even, unless you filled in that address, doesn't even necessarily address that. What else? The hard dates, I mentioned that early on. That frustrates me because you don't know when the seller's even going to sign the contract. If the seller waits 4 days and accepts your offer, you're already eating into that due diligence period, that last day that you set. And then the repair request, like I said, when the seller signs that, the due diligence period is over immediately. So you don't have time for the appraisal, the title, the survey. None of that stuff can be done during due diligence anymore if you deliver that repair request and it gets signed right away. I think that's a problem, but so these are just like another, excuse me.
Water.
Sure, yeah. These are some sort of rhetorical questions of things to be thinking about. I had a request before to put all this in bullet points. I'm still working on doing that on like a PDF. So thanks. From your perspective, when you're sending in an offer, how do you calculate the due diligence period? You've got to factor in, when can I get my vendors out? When's the seller going to accept this? What's the condition of the property? Is this a pretty new, nice looking property, or is this in rough shape? We're going to need more time to look. You want to get all your inspections, surveys, everything you want to do during due diligence if you can. So how do you calculate the termination fee? You got to factor in, where are we at in the market? Is this a seller's market? Does this have to be aggressive? Do we have more leverage here as the buyer? What's the condition of the property? If this is a brand new property, or if it's a almost new construction, the seller's probably not going to allow for as much due diligence. They probably think everything's in pretty good shape. So you might have to go either very high on the termination fee or very short on the inspection. All those are factors that are part of what you do every day. Thank you. And again, one more time, the termination fee, it's all about educating your buyers, educating your sellers. You don't want to think about termination the day you get your offer accepted, but you've got to be prepared for your exit strategy if this property doesn't work out. There's liability on the agents, there's liability on the attorneys involved, everything. If the buyer feels like they weren't informed of these deadlines and they missed something. Number 6 is just an example. The buyer tries to deliver their termination fee at 6:01 on the last day of the due diligence period. That's not valid to terminate a contract anymore. It has to be by 6 o'clock. There's no grace period. There's no wiggle room. It's in the contract. The seller can't waive it. It's by 6 o'clock. After that, the contract becomes as is, and the buyer doesn't have the ability to terminate at that point. And actually, if the buyer tries to terminate after that point, they're potentially exposing themselves to liability for breach by trying to back out of the contract. So 6 o'clock is very, very important. If you're going to terminate, it's got to be on time.
I have a quick question.
Yep.
Is there the ability to extend that termination date like you can with due diligence? Yes.
Right.
If you were up against that as a buyer agent, you could say, hey, can we extend, 24 hours, whatever it might be.
Absolutely. You extend the end date of the due diligence period. And that was, paragraph 8. It's that blank you fill in to say due diligence period expires on this date.
Right. And then could you just give me an example or give us an example, just what you're seeing, as maybe on a, say, $300,000 home, what kind of termination fee are we seeing right now in South Carolina? I mean, how much as a listing agent, what should I expect to be seeing for a termination fee?
Well, again, I think there's some factors involved, like the condition of the property.
Sure.
So if you've got a brand new, nice looking property, the buyer shouldn't need, 3 weeks to do their due diligence, and you might look for something a little bit higher. If it's, in really rough shape, or this is more like an investor deal, kind of a rough property, then obviously that's going to be a little bit lower probably. For just your average resale deal, 300,000, I mean, I couldn't lock in a specific number, but I would say anywhere 1,000 to 3,000 or so maybe is probably
Okay, so we're not talking, $250 or $500. I mean, it's got to hurt. It's got to hurt the buyer a little bit, right? And from a listing or a seller standpoint, you want it to hurt for the buyer to have to walk away, correct?
Right. You want them to have some skin in the game. Otherwise, it's just a free look, right? It's just a flip of a coin. I want this or I don't, and it doesn't really matter. I don't lose any money either way. I see Tommy's comments, market driven. Agree with that, and agree with where we are in the seller versus buyer market. But I mean, right now it feels like sellers still probably have the upper hand mostly, but
Mostly, emphasize the mostly.
feels to me like
Amazing.
within a couple $1,000s is probably a pretty fair game if the rest of the contract is strong.
Okay, thanks.
Compared to Tommy, is there something specific for you're talking about just the due diligence fee for North Carolina, or?
Hey, so I know it's old habits die hard, and we're thinking of that old, where we paid $100 to get out of a South Carolina contract before. My point is, everybody knows they're going to want dollar signs on those blanks now. So just because we're over, the state line doesn't mean it's going to be cheaper. I hate to say it that way, but again, I think it's all. I've seen even here recently lower due diligence fees, accepted So I think it's all on a case by case basis. But again, I think a lot of what's been happening the last year and driving up, due diligence fees, termination fees, I think all that is a result of the type of market we're in. And now, the market's correcting itself. So I don't think we'll have to pay those as high a fee, a termination fee, as we might think.
Right.
But I would say for me, I'm going to negotiate that in the best interest of my client with the other party.
Right. And my takeaway from the South Carolina, as it goes back to the changes that were made this year, is, to me, it was much harder, well, for both sides, when you've got 3 different options, you've got to pick one. And then in one of those options is due diligence, you've got this termination fee. So not every offer you're seeing is competing on the same terms necessarily. Like, how do you compare a repair procedure versus a $2,000 termination fee and due diligence versus as is? Well, now there's not that confusion anymore. So it's all due diligence, and it sort of puts more focus on that termination fee line item.
Right.
Less creativity, if you will, to write up a contract. So there's going to be much more emphasis on competing on that number. So I think that will keep the number up a little bit, but I agree. I think the market is going to drive that back down here soon and already. We had, it was North Carolina, we had a due diligence fee. The highest one I saw was like $100,000 a few months ago. Just stroked a personal check for it and dropped it off at the sellers. We're not going to be seeing that, not in North or South Carolina, hopefully. But the big contrast there is North Carolina, that's non-refundable up front. And in South, at least you're only paying that if you terminate. But it's still a pretty big check to cut for a property you're not going to buy. So
I think that's gonna be the hardest part, is getting your buyer to cut a check when they want to terminate.
after
When they don't want to buy the house.
Well,
you're
especially,
asking them to cut a check.
And again, I think
I like the North Carolina one.
the
where
money
it's
is
up
out
front
and it's
gone.
there. Right.
Okay, hold on a second though. I'm gonna play devil's advocate here.
Okay.
Here's my scenario. I've written an offer. My buyer is doing a $10,000 earnest money, right? We're doing 20,000 in a termination fee. If we're putting our money where our mouth is, right? Now, we get through due diligence period, we're happy. So we're not striking a check. We cancel 2 days before closing. What amount's payable?
Well, that's the earnest money is to be agreed upon the buyer and the seller.
Right, but
So
my
the
fee
seller
is
can
lower.
fight for the earnest money.
They can, but they can't go back and fight me for due diligence.
They can
termination,
fight- they
can they?
have
Sue
to.
you for it.
You have to do the termination because it's agreed upon that you're paying a $20,000 termination.
Only during due diligence.
You're saying they're doing it afterwards.
They're doing it after the due
Yeah.
diligence period.
And that's where, again, this contract just goes out into the
The-
abstract.
right,
It's
'cause there's
the seller
no-
can sue the buyer for whatever damages have been caused and all that. And they might, I haven't read case law on this. I don't really know a good answer on that. I don't know if they'd have a good shot at like saying I was entitled to that termination fee,
Mhm.
but they'd come at anything else, like any other damages that were caused by the buyer.
But it's not assumed though that they're gonna get it based off of what's written here.
Well, and even going to court, even assuming they get a judgment against the buyer, like they still got to get the money. They'll
Yeah.
probably never see that money.
Right.
So I think this contract and everything, the approach relies too much on, well, if the parties don't agree on something here, they can just go to court and settle it there. Like, that doesn't work that way. I mean, it's expensive. It takes forever. The buyer's got, say they put in 20,000 earnest money and they need to back out and the seller won't sign it. Oh, we'll just go sue them for it, right? Well, the buyer needs that 20,000 to go buy the next house, and they need somewhere to live, and
Mhm.
that lawsuit doesn't help them at all. And if they never recover on that lawsuit, it doesn't matter. Now that if the earnest money's in our account, we'd surrender it to the court and it'd get argued about there. But I just think this contract relies too much on just
Good old boy method.
figure it out.
Yeah.
If it doesn't work out, then there's emotions involved. People get upset when it's their personal residence they're selling or they're buying, or
Interesting. Wow, that's gonna be,
I
I'm
just,
excited to see what happens.
and that's
with
not
that.
necessarily even new for this year. I've just felt that way for a while about that contract. But to me, it's just like, and even like the SCR's got their video explaining the contract and the changes and everything. I don't think it's prepared from a perspective of someone who's actually selling houses and dealing with clients, because it feels to me like too, not naive, but it doesn't always work out that way in the real world. Like, things happen, people get upset. I had a buyer's agent yesterday send this pretty condescending email to all of us involved, like basically not like trusting anybody to do their jobs right. And the listing agent got mad and he said, I'm going to send this to the seller and she's going to be mad. And at that point, it doesn't matter what's in the contract. It doesn't matter what they've agreed to. If that seller's mad, they're mad. They're not going to sign something. They're not going to do something. If it's the buyer, they're not going to send that termination fee they're supposed to. Great, they'll go argue about it in court. And then everyone spends more money on attorneys and time. And I just think it opens a lot of possibilities for argument. And at least in North Carolina, there are some situations that are handled in the contract. It talks about earnest money. It talks about termination. But Tommy says, how do we proceed with client after they default? How far do we go to help them?
So what I'm asking here, Charlie, is I know we don't want to get into any gray area where now we're recommending a certain action or not.
Right.
I don't think that's what we're supposed to be doing. So I just thought that might be a good question for those. Like, say if my buyer said, oh, I'm not paying that termination fee.
Yeah, I mean, I think this is not the kind of work I want to create for myself, but I think this is an attorney question. I think they have to understand what the contract says, what the consequences are of that. I don't think it's overstepping for you to say you're supposed to pay that termination fee or else you may be in breach of the contract. You better talk to an attorney before you do that. The moral of the story is inform the buyers that it would be a good idea to talk to an attorney is typically the good answer. It's all about risk mitigation for you. You don't want any kind of accusation that you've been acting as an attorney or giving legal advice. So if you're pounding it into their head, like you need to talk to an attorney, even if they don't do it, they've heard that from you, and there's less possibility of them coming back and saying, I didn't know about that. I was relying on you for that answer. And that's ultimately the end game, is keeping yourself out of trouble.
Yeah, right. Thanks.
Yeah. All right. So I got some potential solutions. We've sort of talked about some of these. The SCR had a suggestion that you make the earnest money due after the due diligence period ends, which I still don't think you'd get many contracts accepted if you did that. But if you're in a buyer's market, that's a different story. You could actually, say the due diligence period ends on July 21st and the buyer has to pay earnest money by July 22nd. And then you go in, look at the property, you don't like it, you terminate. And you never paid the earnest money, you don't have to worry about that. And you still probably have to pay a termination fee, but you can get out fairly cheaply.
You
Again,
don't have to fight over the earnest money. You
Right.
don't have to pay it.
right. Funds not tied up, no
Okay.
fight. If we shift back to more of a buyer's market, that's actually a pretty strong option. But again, as of 3 weeks ago, when I was putting this together, that was a good punchline. So termination fee, we talked about logistics with checks and things. It's 2022. If the buyer and seller can agree to some kind of electronic transfer, they could do Venmo, they could do Zelle, but you have to know the account names. You've got to know their information. You want to ideally send it to the right person and not a stranger. That would be good. So again, you still have to be prepared. You got to get that from the listing agent and say, this is their Zelle account name, send it there. The sellers are good with that. Here are their wiring instructions. You can wire it to them. That still requires the seller to cooperate, even though they don't have to. But you need to be prepared. Termination fee, the location. you got to pick a location that's a reliable place. It can't be, you know, it can't be the bank. Sorry, it can't be the bank branch, and then the bank is closed at 5, and then you got to deliver it by 6. That would be a problem. It's got to be somewhere that's open at 6, ideally, or else a reliable location that can be delivered and confirmed. So it can't be the seller's beach house. It can't be the seller's house while they're away for work. It's got to be someone's there to receive it. Someone can confirm it's been received, and you can prove you've actually done your job before 6 o'clock. We do have I drafted an addendum for this already based on a real situation that happened last week where I just filled in a blank. It just says buyer and seller agree that the termination can be delivered to this address to satisfy their obligations, and that seemed to work. So I'll share that one with everybody. Like I said, as is contract. If you want an as is contract, you just make a very short due diligence period or a really, really high termination fee that's going to keep the buyer from walking away over nothing. And then timing is really, really important for the due diligence. I recommend rush everything you can. Have the buyer pay a rush fee for the appraisal. If you're going to get a survey, you got to expedite that. Those are taking forever. Work with an attorney who's going to get your title back quickly. It's really important to get that piece done before due diligence. Like I said, our team usually within a week or so, or at least about 3 weeks before closing happens, we can get title back pretty reliably. So, and then, you know, I'd say just lastly, it's important you've got a strong team, not just attorneys, but you need a lender who's on your side, you need an attorney, inspectors, contractors who are going to come out, answer the phone. The timing is so important. You've got to know that people are going to jump and act for you when you get under contract. So if you don't have a lender, talk to everybody here. There's some great lender partners with your company. I got others too, but you know, attorneys, even if it's not me or our firm, like I think you need an attorney who will actually pick up the phone, who will actually bump things to the top of the list for you, get things done. I like to think we're pretty good about all those things, but it's really important these days. And as much as we talk about recession, this or that, there's going to be some people that keep selling houses and are very successful, and throughout anything that happens. And in my opinion, that's going to rely on more than ever having the right people around you. It's not just about you anymore. It's your lender answers the phone and gets things done. The attorney gets things done, and everybody else. So that's my big takeaway from that. Does anybody else have any other questions about this or anything related to it? Questions from the audience?
Nope. You answered all mine.
I have a request.
Uh-huh.
I've been taking pictures of all the slides, but I missed number 1. At some point, could you put slide number 1 back up so I can grab a picture of it real quick?
Yeah, of course.
We
Okay,
also have this recorded and we'll throw it up on our private page. So you can rewatch this anytime.
Oh, fabulous. Okay. Well,
This
that
was
will.
for
Uh,
talking about the contract.
yes.
Like
Let's
that?
see. Let me see. No, I think go on one more. It says 1 and then 2. Yep, that one right there.
Okay. Yep.
Thank you. Okay, and this will go, this is recorded, so it will go on and we can watch it over and over and over again.
Yep.
Okay. Thank you.
Sure. Thank you. Well, these are my contact information. There's my email and cell phone. Feel free to call or text. Always happy to talk about questions and scenarios and things. And every time I hear a real world scenario that's happening, it helps me on presentations like this to talk about actual things that are going on and actual concerns. If you feel so inclined, want to work with us, we do have emails right here for contracts. Charlotte is where we take our North Carolina contracts, and then Rock Hill for South Carolina. We would love to work with everybody here. If you've enjoyed working with other members of your team and everybody, so you always know where to find us if you need us.
Cool.
Anything else?
I got nothing, guys. We'll throw this recording up. It was great to see everybody on here, and we'll see you next week, hopefully.
Thank you.
Good day, everybody.
Bye, everyone.
Bye.
Bye.